Right, and the story by Daniel Mule also sets the tone for a conversation here on This Is a Point on AM Live. And of course, before we even drill deeper with our conversation, the question that really remains or is abiding is this. Is the IBC really overplaying its hand with Chapter 6 of the Constitution? Do you think the IBC is overplaying its hand with the Chapter 6 of the Constitution? Hit us on Twitter. AMLiveNTV is a Twitter handle. AMLiveNTV is a profile name on Facebook and 20505 our SMS portal. And of course, we shall be also sampling some of your views much later in the course of the program. Once again, is the IBC overplaying its hand with Chapter 6 of the Constitution? Have we really crossed the Rubicon? Because we know that IBC has already issued candidates with their nomination certificates. And of course, EACC has also submitted 106 candidates in a report who they think they're embroiled in some malaise, economic malaise, or some other, graft here and there. So will that also make any discernible difference? So we're asking you again, is the IBC overplaying its hand with Chapter 6 of the Constitution? Hit us on Twitter. AMLiveNTV is a Twitter handle. AMLiveNTV, our profile name on Facebook, and 20505 our SMS portal. Allow me to introduce our panelists who are already here in the studio to weigh in on this particular story and others as well. As we continue the conversation, we have with us Honorable Kipruto Rapkirwa, who is the Deputy Leader of ANC and also former Minister of Agriculture. Also, we have Ambassador Senator Kembi Gitura, who is a senator from Muranga. We have with us Alice Wahome, Member of Parliament from Kandara. Also, we have Dr. Shem Ochodho, who is a global leader of Kenya Diaspora Alliance, and also Professor Nyong'o, who is a senator from Kisumu. Good morning, gentlemen and lady.
Morning.
Chapter 6. Have we really crossed the Rubicon when we actually look at what IBC is trying to do right now? And the EACC is submitting their report, 106 candidates that have been embroiled in corruption or other malaise. We know that IBC has issued certificates so far. So which way to go? Let's begin with you, Honorable Kipruto Rapkirwa.
Well, first of all, we are privileged to have two lawyers in our midst. They will be able to give us the details.
Yes.
But on the face of it, Chapter 6 addresses the issues of integrity and ethics. As far as ethics are concerned, I don't think you can easily legislate ethics in a way that you're able to capture the imagination of the drafters of the Constitution. On the issue of integrity, yes, probably, but the law that subsequently was made after this is very clear that the due process must be exploited before somebody is convicted, or somebody once convicted and he has not made any appeal to the higher authority in terms of the judicial system, that person, of course, shall be deemed to be not qualified to run for office. But if somebody does appeal, that process must be fully expedited before anybody makes any judgment. In short, I think IBC is either playing to the gallery or is totally out of its depth and therefore is overreaching itself. And finally, also, the issue that they have given certificates already.
Yes. On
what basis were they issuing those certificates? Because they have also to think of how to retrieve a certificate that they have issued to an individual. Otherwise, somebody will go to court, and I'm sure litigation will take the balance of the period.
All right, Balozi.
Well, first of all, I would like to say good morning to everybody who is watching us out there, and state that the question you've asked about integrity is very virgin land, if you ask me, in these issues.
Yes.
But the Constitution is there. The Constitution is clear, and I would agree substantially with Honorable Kipruto Rapkirwa, because we need to read the Constitution as it is written. And if you read Article 99, for instance,
yes,
of the Constitution, it talks about the qualifications and disqualifications for election of a member of parliament. So maybe I can deal with the issue of the member of parliament first. And it talks about how one is disqualified, and it's clear. Person is disqualified from being an elected member of parliament if the person is, it says many things, is of unsound mind, that has nothing to do with integrity, is an undischarged bankrupt, and G, is subject to sentence of imprisonment of at least 6 months, or as at the date of registration as a candidate, or at the date of an election. Now, if you look at chapter 6 of the, then it talks about, in H it says, if it's found in accordance with any law to have misused or abused a state office or public office, or in any way to have contravened chapter 6 of the Constitution. So it doesn't, we all talk about chapter 6, but very few people actually read chapter 6 of the Constitution, because it doesn't say very much. It talks about integrity, which is not very well defined either. So I think the question to ask yourself is, how is a person to be disqualified from running for Senate or for running in the National Assembly? And the answer is in Article 99 of the Constitution. So unless those things are satisfied, in my very considered opinion, unless those things are satisfied, then it becomes very difficult for anybody to say that one cannot, does not qualify to run for those seats. I think that's 99 must be the beginning point.
99 must be the beginning.
99 must be the beginning point.
Maybe the better point will have been to get a draft, the original draft, because as it is right now, we understand also this chapter 6 of the Constitution was adversely mutilated by members of Parliament in the 10th Parliament, right?
But what we have,
if
what
we
we have is
compare
what
the
we
draft,
have.
because now it seems this is really watered down. I mean, should we just expunge this particular chapter 6 of a Constitution in its entirety? Because what purpose is it serving if, right? It's really
the point I'm making is that maybe what was mooted in the draft Constitution would have been better, as you say. I don't know, but
Yes.
what we have here is what we have.
So
Yeah?
the question is,
and we can only go by what we have in the Constitution.
So the question is, what we have in the what purpose it is serving? Because it says until someone is actually convicted.
That's right.
But we've seen in this particular country that, yes, we have so many injunctions, and the people know staying orders also in court until they exercise, maybe when you're going to elections, also cannot be fully implemented. So what purpose is it serving in the first place? Let's say from Dr. Shemocho.
The bill, I wouldn't want to cast aspersions on the judiciary, and allow me also to associate myself with what the two honorable members have said. I think the law in that sub-article 3 of 99, it says a person is not disqualified under the previous clauses unless all possibility of appeal or review of the relevant sentence have been exhausted. Also, Article 80, in terms of legislation in leadership, I think Chapter 6 is an extremely good part of the Constitution, together with Article 10 on national values and principles.
Yes.
So I think it's positive progress. Maybe what Waishimiwa will enlighten me, Parliament was to enact legislation to bring into effect this Chapter 6. Maybe they have done, maybe Mheshimiwa Alice and others can enlighten us. But that's where the beef needs to come out of, because it would be also wrong to have selective application of the law. But I think it's the right way to go. I think we are making progress. My take is that IBC would be looking at things, for example, dual citizenship. You can't hold public office. Although in the last election, one of diaspora members went to court. The court did say that it's not that you can't run for office, it's only that you can't hold. If you are a dual citizen and you get elected or appointed to an office, you must revoke the other nationality to take up office. So there are such clarifications, and I believe that IBC will also be checking people in terms of credit reference bureau and so on and so forth. Of course, they still constitute towards integrity. But yes, I agree with you. Much more clarity needs to have been done by Parliament, but it's probably too late at this point to do it for this election.
Yes, Alice, have we crossed the Rubicon yet?
Dibale, thank you very much this morning. I think when we were here last week,
Yes.
you pressed on an answer for this question needed some clarity.
Yes.
Or some answers, and because it was the week that clearance was happening at the sub-counties and counties, and of course the national level, and I believe the clearance is still going on in terms of documentation. The quick and complete answer right now is that you have to refer to Article 99, which my landed senior, and for this matter, Honorable Kebi Gitura is my landed senior. And he has referred to Article 99, which other colleagues here have actually alluded to, that the fact that you have to exhaust the mechanisms provided under the law. And the Constitution is the beginning, is the foundation of any other law that we come up with. And clearly, if the Constitution has in itself and wisdom, or in the wisdom of the crafters, and of course Kenyans participated in even in the drafting of this Constitution and approval and final enactment, is that they needed, of course, anybody who will be barred from political participation must be processed under the law. If you are a suspect, if you have been found to have interfered or abused offices, or you are corrupt, then the way to prove that you have done that is that then there are other institutions that are supposed to prosecute you. They're supposed to handle you. And until they do that, then we, the rest of us, have to assume and presume, and because the law says so, that you are still guilty.
Right.
So to me, we really, if you have been cleared, unless right now a court order comes saying, look, this person was actually convicted and he has no appeal or subsisting right now. Nothing is pending in courts, so that you have a conviction, and that conviction is actually more than 6 months. You may have a conviction, a traffic offense of 1 day or 5 days. You are still eligible under Article 99. So the disqualification clauses, all these hulabali and whatever we have said, is still saying this person needs to be interrogated in terms of integrity. And we know there are issues, yes, but those issues cannot be passed without processing under the law. We'll be a jungle,
right.
A jungle country also.
The question should be then, because we're seeing an act of the EACC presenting this particular
The
106.
EACC, yes, the EACC
Way
right
too late.
now needs to look through and find out whether there are convictions against some person. That's the first thing. They can stop you if they have a court order with them. And that doesn't even have to be brought by somebody.
All right. So are we likely to see also that some of these leaders who are passing through this particular grid, or so to speak, functioning at the dysfunction of these other institutions? So is it that they are way too slow?
Frankly speaking, I don't know whether it is giving Kenyans hope. I am not understanding the position of IEBC in terms of what they are still looking at this group of institutions.
Yes.
They are late in the day. Me, that is my position. They are late in the day. Whether it is EACC, of course we make declarations. They can take me to court if I have sworn a false declaration, because I'm supposed to answer specific and certain questions. And if I have answered those questions in the negative when it is supposed to be positive, then they can still prosecute you, and then I can be pulled out either of the race before the date of the race. And of course I can protest and say it is not okay until the court now says, look, I think you cannot run. So
where the court also may stay the order, slap injunctions, and of course we scuttle the whole process again, then we're in the same rotten mire.
You see, you are not taken to court the same day and then you are, you are processed. It's not possible. There is procedure. In court, there is procedure of litigation, which has defense.
Right, and this is the problem that I think also we would take umbrage with this morning.
Yes.
That the whole process is way too slow on the uptick, until we can see, you mentioned the 6 months before even the general election itself of conviction, isn't it? Right? If they submit the list right now,
the conviction must be more than 6 months.
More than 6 months.
Yes, say like the conviction itself, can be 1 month, can be 2 months. I will still not be disqualified. But if it is 7 months, then I'll be disqualified.
Of which right now we are barely how many months to go to the general election?
No, you are not getting it.
Yes.
You see, when you are sentenced, maybe the sentence, there is a conviction, and the sentence.
Yes.
The sentence itself must be of more than 6 months.
More than 6 months.
Yeah, the sentence.
All right, thank you. Let's hear from Professor Nyong'o. First of all, you think this is an institutional failure?
No, first, good morning.
Good morning.
And my colleagues. First, I think as Senator Kembe says, we have a law, we have Chapter 6. That is what we have. We can't rely on anything else. We also have other laws, the Integrity Code and all that. I think what really should happen is for the agency which are in charge of integrity. Ethics and Anti-Corruption Commission, Kenya Integrity and National Cohesion, IBC, and so on. What they should do is start this process much earlier. Much earlier, 2 years earlier.
Yes.
And maybe they may require law in Parliament, which law the IBC should draft or something like that. But they should chart it earlier that if you intend to stand for elective position next year or when the elections come, please submit your names or something so that vetting starts earlier. I think now people who say it's like a punitive exercise may be right, unfortunately, because there is very little time, as Ali says, to have due process undertaken. And therefore, if you summarily stop somebody for standing for elections because he has questions of integrity, and yet you don't give them time to go to court and clear themselves in any way, it doesn't look tidy. So I really think that it's a question of not implementing the law properly, not starting due process in good time to give everybody a fair chance of clearing themselves because they're accused of issues of integrity. Of course, I'm chairman of the Public Accounts and Investments Committee of that Senate. I know people have issues of integrity, but at the same time, we can't run away from the law. If there is a question about your issue of integrity, you should be allowed to have your day in court so that you are cleared or you are convicted. But waking up on the eve of the elections and rushing to the Ethics and Anti-Corruption Commission, give us a list of people with integrity and getting there and making the headlines in the papers, it doesn't look neat, really, I would say. I think it's rather unfortunate.
All right. Let's hear from Professor. Balozi.
There's only one professor on this panel, and that is Professor Nyong'o. I think there is general consensus of this issue. Yes. And I think it's good to tell the people, the truth as it is, because we talk about integrity, we talk about Chapter 6. But like I said earlier, very few people delve into it to see exactly what it says. But let's look at it, if you allow me. It talks about leadership and integrity. It talks about, it defines responsibility of leadership, right?
Yes.
But the most important part, in my view, is 73.1, 73.2. It talks about the guiding principles of leadership and integrity. And this include, for instance, selection. And choose the word selection, not election. Selection on the basis of personal integrity.
Yes.
Then it talks about competence and suitability, or election in a free and fair elections, right? Now, selection assumes a panel, an interviewing panel.
Yeah.
It assumes that you are being interviewed, you have a CV, and people can ask you, is it true you are convicted of theft? Or is it true that you've been taken to the EACC so many times and you've been before Professor Nyong'o's committee at the Senate and they think you are a thief? All those things. That presumes, in my view, an interviewing panel that looks at you and raises all these issues. But I have said this, and I'm on record and saying this, and at the risk of repeating myself, I think the institutions that we have, the EACC, the Judiciary, and the DPP, and all those others, are the ones that should be on the chopping board. They're the ones that should be answering these questions. Because there are so many issues of integrity that are pending against so many people. And the EACC, I don't want to say it's slow, sometimes it looks like it's almost deliberate because it's taken so long to deal with these issues. Yeah. Professor Nyong'o is the chairman of the Public Accounts and Investments Committee of the Senate, and I say this because I've attended these sessions, has worked so hard with this committee to bring out these issues so that the relevant bodies can then look into them, investigate, and follow up. But we have seen that he's tabled so many reports, nothing has happened, and he cannot himself prosecute, he doesn't have that power. He cannot take you to court himself, but he's done his bit and pushed that responsibility to the next person in that line, who normally is the DPP, is the EACC, and so those people who are charged with that public responsibility. Now, when they come in the last minute and talk about integrity, and when people are going to elections, they're either, like we said, they're either playing to the public gallery, or they want to show that they are still following up these issues. But what do they expect people to do? What, except for creating maybe despondency and unrest and things like those? What do they want people to do now? And they know that there is Article 99 of the Constitution. They know there is the 6 months imprisonment that Honorable Alice Wahome has talked about. I mean, it's not good to give people false hope.
Right.
Yeah. Some of these things are things that ought to have been done in good time, so that there is no ambiguity as of this moment, and everybody is clear in their minds that I'm not going to elections because I know I've been convicted for 6 months, and I know that there is no appeal pending. I know there's even a person in prison right now who the IBC said can run for elections because there are so many appeals pending. The appeals are still pending. So technically, he qualifies, satisfies Article 99 of the Constitution, and nobody can say that he doesn't satisfy it, although he is in prison, serving, I think, 7 or 12 years imprisonment.
Okay, but can we also question the efficacy of this particular Chapter 6 of the Constitution? Because as it is right now, we know also the Commission, the Kenya National Human Rights Commission, has moved to courts to get an advisory opinion of the Chapter 6 of the Constitution, right, to make it very limpid.
Well, but I think we cannot say that Chapter 6 is not efficacious. It is efficacious. The Constitution is there to lay general principles for lawmaking. It states broad general principles that laws should be based on. And therefore, unless you disagree with these principles in the Chapter 6, then you can say the Chapter 6 is not efficacious. But you have to show us that these principles are not relevant to governance, good governance and democracy, which they are. You have to show us these principles are not relevant to people who are electing people integrity, which they are. I think what the Deputy Speaker and myself are saying, given Chapter 6, law enforcement agencies have failed to respond to the prerequisites of Chapter 6 by following what lawmakers have done to ensure that integrity is observed. That's the whole point. You know, this chapter says that Parliament shall enact a law to establish the Ethics and Corruption Commission. Parliament did enact such a law and gave the Ethics and Anti-Corruption Commission powers to do its job. Parliament did enact a law to have a National Integrity and Cohesion Commission, to have powers to make sure there is national integrity and cohesion. In fact, a lot of these things you see here really are in the court of law enforcement agencies and law adjudication agencies in the law courts. You see what I mean? Now, the problem in Kenya is the speed with which these institutions work is too slow. Their own integrity is also in question. That's the problem.
So the slowness, the glacial slowness that we have, is it deliberate? Because now if we have slowness and it's not really working, you tend to scuttle the whole process itself. I don't know what you think, Honorable Kiwa.
Well, three things come into play. The issue of capacity of these institutions, whether they are effectively empowered with the requisite resources for purposes of prosecuting these issues and delivering effective results. The other issue is, are they truly independent as they ought to be? And finally, the question of functionality. Are they functioning? Are the individuals themselves have the requisite capacity to perform? And this brings us to the issue that justice delayed is justice denied. Because if I have a case that has been pending on me for the last, let's say, for 2 years or 3 years, you are being unjust to me, because deal with me, acquit me, or convict me. These are things that should be done. But also let's remind ourselves that a president has been set in the last general election, 2013, where the two leaders in power today were taken through a court of law, and it was the court pronounced itself that they were fit to run because they were presumed to be innocent until such a matter is dispensed with fully. So in the language of the lawyers, they talk of precedents, and if that precedent has been set, really who are we now to start engaging in trying to improve the moral bar? And the moral bar really cannot be legislated. It has to do with what our society does believe in. So let's really cross that, and I hope the institutions will be independent, will have the necessary capacity, and also functioning fully to dispense with such cases.
All right, thank you. Let's hear from Dr. Shamachodo.
The bill, I know there are, first of all, the National Commission on Human Rights has got a right to seek interpretation of the law from the Supreme Court. So that they're very much in line with, that's provided for in law. I would also be slow at criticizing the institutions that are not represented here because they can't defend themselves. But I would go back to Article 8, which talks of legislation on leadership and integrity. Are we saying that establishing the institutions, the independent institutions that Professor has very eloquently elaborated on, the NCIC, the EACC, and the others, was that enough, together with the Integrity Court? Because Article 80A says, Parliament shall enact legislation establishing procedures and mechanisms for the effective administration of this chapter, Chapter 6. Are we convinced that that's been done? But also when we casting aspersions on the other independent commissions, what about Parliament itself? We know Kenyans have had issues with Parliament itself on probity and integrity. So my premise is that I think we've got a problem as a nation. But I am happy that it's being addressed. We probably just need to expedite it. I think we're on the right track. We need to do more in the next electoral cycle. But I agree with my colleagues for now. I don't think there is much else that can be done for this particular election.
All right. With the court orders maybe notwithstanding, should we maybe have also timelines given to EACC when it comes also to making sure they expedite their work?
I think you're right. I think the point that Shem makes about Article 80 is very important, I think. This idea that Parliament shall enact legislation establishing procedure and mechanism for the effective administration of this chapter. I think we have failed, because I think we should make legislation giving these fellows timelines, giving the IEBC when to start looking for issue of integrity.
Yes.
And of course, when Shem says that even in Parliament we have our own, that's true. I think all have fallen short of grace.
Sure.
Right.
I just wanted to weigh in briefly and say, let's not make Kenyans lose hope, or like the enactment was in vain of Chapter 6. Right. First and foremost, there are very many public jobs. These elective positions or jobs are just some of the public jobs that are there. And integrity chapter, the Chapter 6 is still being utilized in recruitment of and hiring and vetting of other public officers, actually, including through Parliament. So that is one. And because there is on the part of elective, it is because Article 99 goes further to outline the disqualification, or criteria that one must go through or be assessed from. But otherwise, Chapter 6 is still being utilized. Secondly, I think, as you said, even Kenyans have become also a problem in ourselves, because the judiciary, even as we want to criticize it for possibly sometimes delay, unnecessary delay. You saw some Kenyans went to court, or some Kenyan went to court and said you cannot have special courts. You see, and a special court sometimes are necessary, or special divisions that will tackle and handle specific matters, so that in terms of moving them forward, there is a concerted effort and attention in terms of clearing those cases. But I think investigatory system is the one that we really need to fast track very quickly, and then when we reach to the courts, then we must have very strict timelines. I think that is what we are saying. And those timelines can also be set within the law, where we can amend and set timelines within the law, within what time should specific matters be finalized.
Thank you.